Don't start lying to me. We know your type uses fake names to hide.
My name is Judge Angelique Jones. You have no warrant.
Yeah, and I'm supposed to believe that? You think that title protects you?
You're violating the law.
At 6:49 a.m., inside a private recovery room at St. Clement's Medical Center, two ICE agents in full tactical gear forced open the door and walked in on a black woman lying in a hospital bed. The woman was Judge Angelique Jones, 54, a sitting United States Federal District Court judge for the Eastern District of Virginia. She had undergone emergency surgery just 14 hours earlier. She was connected to an IV drip, a heart monitor, and a post-operative drainage tube. She could not stand. She could barely lift her arms. The lead agent, Vincent Graff, walked straight to the bed and grabbed her wrist. His partner, Samuel Denton, stood at the foot of the bed and demanded identification. Neither agent had a warrant. Neither had verified who was in the room. Neither had spoken to a single doctor or nurse before entering. The hospital security camera in the hallway captured both of them walking in. The body camera mounted on Graff's chest was recording, and what it would capture over the next several minutes would trigger a federal investigation, end multiple careers, and become one of the most viewed clips of law enforcement abuse in the country. Before we go any further, comment where in the world you are watching from, and make sure to subscribe because the next story is one you absolutely do not want to miss. To understand how outrageous this moment truly was, you need to know who was lying in that hospital bed. Judge Angelique Jones was born in Baton Rouge, Louisiana, and raised by a single mother named Eileen, who cleaned office buildings at night so her daughter could attend school during the day. Angelique graduated top of her class at Howard University, then earned her law degree from Yale, where she made law review. She clerked for a United States Supreme Court justice, spent 8 years as a federal prosecutor handling civil rights cases, then moved into private litigation, where she spent 6 more years representing victims of unlawful detention and government overreach. When the president nominated her to the federal bench, the Senate confirmed her 94-6. She was known for her sharp legal mind, her fairness to both sides, and her unflinching willingness to hold law enforcement accountable when they violated the Constitution. In the 18 months before that hospital room door was forced open, Judge Jones had ruled against unlawful ICE detentions 3 separate times, ordering the release of detained immigrants, and issuing written opinions that called out what she described as a pattern of constitutional indifference within the agency. She was deeply respected in the legal community. She was also deeply resented by certain agencies who did not appreciate being told they had to follow the law. And on that morning, lying in a hospital gown with surgical tubes still in her body, she became the target of the very kind of abuse she had spent her entire career fighting against. Agent Vincent Graff was 42 years old and had been with Immigration and Customs Enforcement for 16 years. He had built a reputation inside the agency as someone who got results. But the way he got those results had left a trail of damage that his supervisors chose to ignore. Over the past 9 years, 11 formal complaints had been filed against Graff by detained individuals alleging excessive force, verbal abuse, and racial targeting. Every single one had been reviewed internally and dismissed. Colleagues described him as someone who doesn't ask twice. That phrase was meant as a compliment inside certain circles of the agency. What it really meant was that Graff used intimidation as a first resort, force as a second, and paperwork as a way to clean up whatever mess came after. His partner, Agent Samuel Denton, was 36 years old with 8 years on the job. Denton was a follower. He deferred to Graff on every call, every decision, every confrontation. He didn't challenge, he didn't question. He watched and he complied. On 2 prior occasions, Denton had stood by while Graff escalated the use of force against detained individuals. Both incidents were caught on surveillance footage. Both were buried by supervisors who decided the complaints weren't worth pursuing. Together, Graff and Denton had been dispatched to St. Clement's Medical Center based on a single anonymous tip. The caller claimed that an undocumented woman was recovering at the hospital under a false identity. The tip included a room number. No one at the field office verified the tip. No one checked hospital records. No one contacted the facility. No one obtained a warrant. The room number belonged to Judge Angelique Jones. Graff pushed the door open without knocking. Denton followed a step behind. The room was dim, the blinds still drawn, the only light coming from the glow of the heart monitor and the IV pump beside the bed. Judge Jones lay under a thin hospital blanket, her gown visible at the collar, tubes running from her arm and her side. She was groggy from pain medication administered just 2 hours earlier. Her eyes opened slowly as the door swung wide and 2 men in tactical vests stepped inside. Graff didn't wait. He announced that they were federal agents with ICE and demanded she identify herself. Jones blinked, her mind working through the fog of medication. She said her name. She said she was a federal judge. Graff looked at Denton and let out a short laugh. "Sure you are." He told Denton to check the bed and her personal items. Denton moved to the side of the room and began going through her overnight bag, pulling out clothing, toiletries, and a book. Her judicial credentials, her federal ID, and her personal phone were inside a locked drawer built into the bedside table. Graff pointed at it. "Open that." Jones's voice was strained but clear. "No, I don't consent to a search. You don't have a warrant." Graff leaned closer. "You don't have rights right now. You have instructions." The heart monitor began to spike. The beeping quickened, filling the small room with a rhythm that matched the rising tension. Out in the hallway, a nurse heard raised voices coming from a room that was supposed to be quiet. A room that held a post-surgical patient who was not supposed to be disturbed for any reason. She turned and started walking toward the door. The door opened and Nurse Priscilla Duval stepped inside. Duval was 58 years old and had worked at St. Clement's for 28 years. She had seen families fall apart in these rooms. She had held the hands of patients who didn't make it through the night. She had never once allowed anyone to compromise the safety of someone in her care, and she was not about to start now. She looked at the 2 agents standing over her patient and spoke immediately. "You need to stop. This woman is a post-surgical patient. She cannot be disturbed, moved, or agitated. She is under medical supervision, and I need you to step away from the bed right now." Graff turned to face her. His expression didn't change. "Leave the room. This is a federal matter." Duval didn't move. "I'm not going anywhere. I'm calling hospital security and the attending physician. You are not authorized to be in here." Graff took a step toward her. "Interfering with a federal operation is a crime. You can be arrested right here, right now. Do you understand that?" Duval met his eyes and did not flinch. "Then arrest me. But you are not touching my patient again until someone with legal authority tells me otherwise." Denton shifted his position and moved to block the doorway, standing with his arms folded across his chest. Behind him, the hallway was still and quiet. But not for long. From the bed, Judge Jones's voice cut through the tension. It was strained from pain, but steady and deliberate. "I am a United States Federal District Court judge. You are in my hospital room without a warrant. You are violating my Fourth Amendment rights. Leave immediately." Graff didn't even look at her. He reached toward her wrist, pulling a zip tie from his belt. The moment his hand closed around her arm and pulled, Jones gasped. The movement sent a sharp jolt through her surgical site. Her body tensed, her face twisted. The heart monitor screamed. The alarm filled the room with a high-pitched, continuous tone that carried through the open doorway and down the corridor. Within seconds, footsteps were coming from every direction. Medical staff were running. "Doctor!" Solomon Osai came through the door at a pace that made Denton step aside before he could think about it. Osai was the attending surgeon who had operated on Judge Jones the night before. He was tall, composed, and not a man who raised his voice unless the situation demanded it. This situation demanded it. He moved directly between Graff and the bed and placed himself there like a wall. "Do not touch my patient again. If you put your hands on her one more time, I will call 911 and this hospital's legal department at the same time, and you will explain to both of them why a post-surgical woman is being physically handled by 2 men with no medical authority and no warrant." Graff opened his mouth to respond, but Osai was not finished. "Step back. Now." 2 hospital security guards appeared in the doorway, both breathing hard from the sprint down the corridor. One of them spoke immediately. Do you have a warrant? Show us a warrant or identify your legal authority to be in this room.
Graf straightened. We don't need a warrant. We're acting on credible intelligence regarding an undocumented individual in this facility. Dr. Osei shook his head slowly. This woman is Judge Angelique Jones. She has been my patient for 2 years. She is a United States citizen. She is a federal judge. And you are standing in her recovery room harassing her after major surgery. For the first time since entering the room, Graf hesitated. His jaw tightened. His eyes moved from Osei to the security guards to Duval and then back to the bed where Jones lay with tears running down her face, one hand pressing against her surgical site. Denton leaned in and whispered, "We need to go." Graf shook his head. "We need to confirm her story." He pulled his radio from his vest and keyed the channel, calling his field office for verification. While he waited for a response, he looked at Denton and gave a short nod toward the door. "Stand there. Nobody in or out until I get confirmation." Denton moved to the doorway and planted himself. A sitting United States Federal District Court judge was now being physically detained in her own hospital bed by 2 ICE agents who had no warrant, no verified intelligence, and no legal ground to stand on. The hallway security camera recorded every second. Patients in neighboring rooms stood in their doorways watching. Staff members lined the corridor, and the body camera on Vincent Graf's chest kept blinking red, capturing everything from his own perspective, building the evidence that would eventually destroy him. While Graf stood at the foot of the bed waiting for his field office to respond, the hospital's chief administrator was 3 floors up making a phone call that would change the course of everything. The administrator had been briefed by security within minutes of the alarm going off. When she heard the words, "federal judge," she didn't call the police. She didn't call ICE. She called the United States Marshals Service, the agency specifically responsible for the protection of federal judges. Within 12 minutes, Deputy U.S. Marshal Franklin Yates was on the phone with the hospital. He confirmed Judge Jones was assigned to the Eastern District of Virginia. He confirmed she was a sitting Article III judge. He confirmed there was no active warrant, no detainer, no federal order of any kind associated with her name. Within 20 minutes, 2 marshals walked through the front entrance of St. Clement's Medical Center, badges displayed, sidearms holstered, and moved directly to the 3rd-floor recovery wing. When they entered the room, Graf was still standing at the foot of Jones's bed. Denton was still blocking the doorway. Dr. Osei was still positioned between Graf and his patient. The heart monitor was still beeping faster than it should have been. Marshal Yates stepped forward and identified himself. He looked at Judge Jones, asked her to confirm her name, her title, and her district. She did. The verification took less than 90 seconds. Then Yates turned to Graf. His voice was calm and controlled, but every word carried weight. "You are standing in the hospital room of a sitting Article III federal judge, without a warrant, after physically touching her against her will. Do you understand what you've done?" Graf's mouth opened. He started to speak. He mentioned the anonymous tip. He said his field office had dispatched them. He said they were following protocol. Yates cut him off. "Step into the hallway. Now." Denton moved immediately. He dropped his arms, stepped out of the doorway, and stood against the corridor wall without a word. Graf lingered. He looked at the marshals, then at Dr. Osei, then at Jones. Then he turned and walked out. The marshals secured the room. Nurse Duval returned to the bedside. Judge Jones was shaking. Her face was wet with tears. Her hand was pressed against her side where the surgical site had been pulled during the struggle. A dark stain was beginning to spread beneath the bandage. Dr. Osei leaned over her and looked at the wound. He straightened and called for an emergency wound reevaluation. The bleeding had started again. Within the hour, the hospital moved with a precision that matched the severity of what had just happened. The chief administrator issued a legal hold on all security footage from the 3rd-floor recovery wing, the hallway cameras, the entrance lobby, and the elevator corridors. Every frame, from every angle, was preserved and locked. No one could access, edit, or delete a single second of it without authorization from the hospital's legal counsel.
The U.S. Marshals flagged the body camera footage from Graff's chest unit for immediate federal preservation. A formal request was sent to ICE's Evidence Management Division, demanding the footage be secured and copied before anyone in Graff's chain of command could review or alter it. Nurse Priscilla Duval sat down at the nursing station and wrote a detailed incident report. She documented the time the agents entered, what they said, how they spoke to her patient, the threat Graff made against her personally, and the moment he grabbed Judge Jones's wrist hard enough to cause her to cry out and trigger the heart monitor alarm. She signed it and submitted it to hospital administration before her shift ended. Dr. Osei documented everything from the medical side: the reopened surgical wound, the elevated heart rate, the spike in blood pressure, the trauma response visible in a patient who had been stable and resting just 1 hour before the agents forced their way in. He noted that the physical confrontation had set back her recovery and introduced a risk of infection at the surgical site. 3 other patients on the floor provided witness statements. One described hearing a woman crying and a man yelling. Another described 2 men in tactical gear blocking a doorway while nurses tried to get through. A third said she heard someone say the words, "You're hurting me," and that the voice sounded weak, like someone who could barely speak. But the piece of evidence that would travel the farthest didn't come from a hospital camera or a body cam. A janitor named Terrence Hollis had been mopping the hallway outside Judge Jones's room when the agents entered. When the voices got loud, he pulled out his phone and hit record. The video was 40 seconds long. It showed Graff through the open doorway gripping Judge Jones's wrist while she lay in the bed. Her voice was audible. "You're hurting me. I just had surgery." The clip was shaky and the angle was narrow, but the image was clear enough and the words were loud enough to leave no room for doubt. That 40-second video would eventually reach millions of views and become the single most watched piece of footage from the entire case. The U.S. Marshals didn't wait. Before Judge Jones's wound had even been rebandaged, a formal notification was sent to the Department of Justice in Washington. The report was flagged urgent. It described the warrantless entry into a hospital room, the physical detention of a sitting Article III federal judge, the use of force against a post-surgical patient, and the presence of body camera footage and multiple witnesses. Within hours, the DOJ's Office of Professional Responsibility opened a preliminary inquiry. The file was assigned priority status, and a team of federal investigators was designated to handle it. That same afternoon, the Chief Judge of the Eastern District of Virginia was personally briefed by phone. He listened without interruption. When the briefing was finished, he issued an internal memo to the entire court system. The language was direct and unsparing. He called the incident a fundamental violation of judicial independence and constitutional protection, and stated that the physical assault and detention of a federal judge in a medical facility by agents operating without legal authority represented a direct threat to the functioning of the judiciary itself. The Federal Judges Association, a body that rarely made public statements, released one that evening. It expressed what it called grave alarm at the reported physical detention of a sitting federal judge without a warrant, without probable cause, and without any legal basis. Congressional offices began receiving calls from constituents, advocacy groups, and legal organizations. By evening, cable news had picked up the janitor's phone video. The 40-second clip played on loop across every major network. The image of a woman in a hospital bed saying, "You're hurting me," while a man in tactical gear gripped her wrist was impossible to explain away, impossible to spin, impossible to ignore. ICE headquarters in Washington scrambled. A public affairs team drafted a statement saying the agency was aware of the incident and was reviewing the circumstances. Internally, the tone was very different. Senior officials were furious, not at what had happened to Judge Jones, but at the exposure. The anonymous tip that had triggered the entire operation was traced within days. It had come from a burner phone. The number had no registered owner. Investigators quickly began to suspect the tip was retaliatory. Just 6 weeks earlier, Judge Jones had issued a ruling ordering the release of 14 detained asylum seekers after finding that ICE had held them in violation of due process. Her written opinion had included a line that had circulated widely within the agency and had made her no friends. She had described what she called a pattern of constitutional indifference embedded in the agency's enforcement culture. Someone, investigators believed, had decided to make her pay for those words, and they had used a phone with no name attached to do it. Federal investigators received the full body camera footage from Graff's chest unit 3 days after the incident. The file was 22 minutes long. It was reviewed in a secure room at the DOJ by a team of attorneys and civil rights investigators. What they saw was devastating. The footage began in the hospital corridor. Graff and Denton walked side by side toward the room. Just before reaching the door, Graff leaned slightly toward Denton and spoke in a lowered voice. The body camera microphone picked it up clearly. Another one, using a fake name. These people always have a story. Investigators paused the footage and replayed that line 4 times. They flagged the phrase, "these people," and marked the timestamp. The footage continued. Graff pushed the door open without knocking. The camera captured the dim room, the monitors, the IV stand, and Judge Jones lying in the bed, eyes barely open. Graff announced himself and demanded identification. Jones responded. She gave her name. She said she was a federal judge. The camera recorded Graff's reaction. The short laugh, the words, "Sure you are," spoken with a dismissiveness that would be replayed in courtrooms and on television for months. The footage showed Denton going through her overnight bag. It showed Graff ordering her to unlock the bedside drawer. It captured her refusal and his response. "You don't have rights right now. You have instructions." It captured Nurse Duval entering the room and telling them to stop. It captured Graff threatening to arrest her for interfering with a federal operation. It captured the moment Graff reached for Judge Jones's wrist with the zip tie, the gasp of pain, the sharp movement that pulled at her surgical wound, and the heart monitor alarm that followed. It captured Dr. Osei entering and positioning himself between the agent and the bed. It captured Graff refusing to leave. It captured him ordering Denton to guard the door. And it captured the arrival of the U.S. Marshals, the verification of Jones's identity, and Marshal Yates telling Graff exactly what he had done. Every second of it was recorded by Graff's own equipment, from his own perspective, in high definition with clear audio. Investigators cross-referenced the footage with ICE's internal dispatch records. What they found deepened the case significantly. Over the previous 4 years, Graff had been involved in 94 field operations. Of those, 78 had targeted Black or Latino individuals. The pattern was overwhelming and consistent. Taken together with the whispered comment before entering the room, it painted a picture of racial bias that was not incidental, but systematic. The footage and the dispatch records were compiled into a sealed evidence package and shared with the DOJ's Civil Rights Division. The investigation was no longer just about what happened in one hospital room. It was about how long it had been allowed to happen everywhere else. ICE moved fast, but not fast enough to stay ahead of the damage. Within 48 hours, both Graff and Denton were placed on immediate, unpaid suspension. Their credentials were confiscated, their firearms were collected, their access to federal systems was revoked. But the fallout didn't stop with the 2 agents. It climbed upward. Investigators pulled the internal dispatch log and found the name of the man who had approved the operation. Agent in charge, Rodney Sloan, 51, a field supervisor with 19 years at ICE, had received the anonymous tip, logged it, and authorized the hospital entry. He did not verify the tip. He did not request a warrant. He did not contact the hospital. He did not run a basic check on the room's occupant, a step that would have taken less than 5 minutes and would have immediately revealed that the patient was a sitting federal judge. Sloan was suspended the same week, but what investigators found next was worse. Every one of Graff's 11 prior complaints had been reviewed and closed at the supervisory level. Every single closure had been signed by Rodney Sloan. For 9 years, Sloan had personally ensured that no complaint against Graff ever moved beyond his desk. Excessive force, verbal abuse, racial targeting, all of it filed and dismissed by the same man who had just sent Graff into a federal judge's hospital room without a warrant. 3 additional supervisors who had co-signed complaint closures were placed under formal review. ICE's Office of Professional Responsibility opened a full internal investigation spanning 5 years of Graff's operations. Every case, every arrest, every closed complaint was reopened. In a rare move, the union that represented ICE agents publicly distanced itself from Graff, issuing a statement saying it could not defend actions that clearly fell outside the bounds of lawful conduct. The collapse was no longer about one hospital room. It was pulling apart an entire chain of command. Judge Jones was discharged from St. Clement's 8 days after the incident. Her recovery had been set back by the reopened wound and the trauma of what happened in her room. 2 days after returning home, she released a written statement. It was measured, precise, and devastating. She described being woken from a medicated sleep by 2 armed men who did not identify themselves. She described the confusion of opening her eyes to tactical vests and raised voices, while her body was still connected to monitors and tubes. She described being told she did not have rights. She described the moment an agent grabbed her wrist and pulled, and the pain that followed as her surgical wound tore. Then she wrote the line that would be quoted everywhere. I have spent my career upholding the Constitution from the bench. I never imagined I would have to invoke it from a hospital bed to protect my own body. She confirmed she would cooperate fully with the DOJ investigation and that she was weighing civil action. Legal scholars noted that assaulting a sitting federal judge could constitute a federal crime under statutes protecting judicial officers from interference and physical harm. Civil rights organizations called it one of the most egregious abuses of federal law enforcement power in recent memory. The NAACP called it racial profiling taken to its most extreme conclusion. And across the country, millions of people watched the janitor's 40-second video one more time and saw a black woman in a hospital bed telling a man in a tactical vest that he was hurting her. The Department of Justice announced the charges on a Tuesday morning. Vincent Graff was charged with deprivation of rights under color of law, under 18 U.S.C. Section 242, assault of a federal official, and unlawful entry and detention without a warrant. Samuel Denton was charged with aiding the deprivation of rights and failure to intervene. Rodney Sloan was charged with supervisory negligence resulting in civil rights violations and obstruction of justice for his role in systematically burying complaints against Graff over a period of 9 years. All 3 were formally terminated from ICE the same day. Their federal law enforcement credentials were permanently revoked. Their badges, firearms, and agency identification were surrendered. Graff's attorney moved quickly, filing motions to dismiss the charges. His central argument was that the anonymous tip had provided reasonable suspicion and that Graff had acted within the scope of his duties. The federal judge reviewing the motions denied every single one. In her written ruling, she called the argument an insult to the Fourth Amendment and stated that an unverified anonymous tip directed at a hospital patient does not create reasonable suspicion, does not authorize warrantless entry, and does not give any federal agent the right to lay hands on a citizen in a recovery bed. The trial lasted 9 days. The prosecution laid out its case methodically. They played the body camera footage from start to finish. They played the hospital surveillance video showing both agents entering the corridor and Denton blocking the doorway. They played the janitor's 40-second phone recording. They entered into evidence the medical records showing the reopened surgical wound and the trauma-induced cardiac event triggered by the confrontation. Nurse Duval took the stand and described what she saw when she entered that room. Dr. Osei testified about the physical damage caused to his patient. The U.S. Marshals described what they found when they arrived. Then Graff took the stand. He insisted he was following protocol. Under cross-examination, he could not name the protocol. He could not produce a warrant. He could not explain why he ignored a federal judge identifying herself to his face. He was asked about the phrase, "these people," captured on his own body camera seconds before entering the room. He said it wasn't racial. The prosecutor asked him what it meant. He had no answer. The jury was shown the footage one final time. They deliberated for 6 hours. Graff was found guilty on all counts and sentenced to 5 years and 4 months in federal prison. Denton, who had cooperated with investigators and pleaded guilty before trial, received 22 months. Sloan, whose 9-year pattern of burying complaints had enabled everything that happened in that hospital room, received 30 months for obstruction and supervisory negligence. Judge Jones filed a federal civil rights lawsuit against ICE, the Department of Homeland Security, and the individual agents involved. The case cited unlawful detention, assault of a federal official, warrantless entry, racial profiling, and deliberate indifference by supervisory personnel who had enabled years of misconduct. The evidence was so overwhelming that the government's attorneys never let it reach trial. The case settled for $4.6 million, one of the largest individual settlements in a federal civil rights case involving a judicial official. But the money was not the point. The settlement included mandated reforms that would reshape how ICE conducted operations for years to come. Independent oversight of all field operations involving hospitals and medical facilities. Mandatory warrant requirements before any agent could enter medical premises. A formal review process for all anonymous tips before action could be authorized. And a national audit of every dismissed complaint filed against ICE agents over the previous decade. Judge Jones returned to the bench 4 months after the incident. She walked into her courtroom the same way she always had, composed, prepared, and unwilling to let anyone believe she had been broken by what happened to her. Her first case back involved an immigration detention challenge. She heard the arguments, reviewed the evidence, and ruled from the bench. In her written opinion, she included a single line that was quoted on every network, in every legal journal, and across every corner of the internet where people had followed her story. No badge outranks the Constitution. Not in my courtroom, not in my hospital room, not anywhere. Back at St. Clement's Medical Center, a framed article about the case hung in the third-floor nursing station. Nurse Duval had put it there herself. The janitor's 40-second video reached 11 million views. This case was brutal, but the case on the right spirals completely out of control.
Ma'am, I said ID now. Stop playing games.
I've committed no violation. You have no lawful basis for this stop.
You're in an area known for illegal crossings, and you expect me to just assume you belong here?
I am a federal judge.
You are making a catastrophic mistake.
Judge Vanessa Sterling had been a federal judge for 12 years. She'd presided over hundreds of cases, interpreted constitutional law, and sworn an oath to uphold justice. But none of that mattered to the 2 ICE agents standing outside her car at a Shell gas station on a Tuesday morning. They saw a black woman in professional attire and made an assumption that would cost them everything. She was filling up her Mercedes before heading to the courthouse. The gas pump clicked. She replaced the nozzle. That's when the unmarked SUV pulled up behind her, blocking her exit. 2 men stepped out wearing tactical vests with ICE printed across the chest. Agent Kyle Brennan and Agent Travis Mendoza had been with Immigration and Customs Enforcement for 8 and 6 years, respectively. They were about to make the biggest mistake of their careers. Judge Sterling asked again what violation justified the stop. Brennan repeated his demand for identification. His hand rested on his belt near his weapon. Mendoza circled around to the passenger side of her vehicle, peering through the windows. Other customers at the gas station started watching. Someone pulled out their phone. "I'm a federal judge. This stop is unconstitutional. You have no authority to detain me without reasonable suspicion of a crime." Brennan smirked. "Sure you are. And I'm the president. License and registration. Last time I'm asking nicely." What happened next would be dissected frame by frame in federal court. Judge Sterling, maintaining her composure despite the rage building inside her, slowly reached into her purse. She pulled out her judicial identification, the kind issued only to sitting federal judges, complete with her photo and the seal of the federal judiciary. She held it up clearly. Brennan glanced at it for maybe 2 seconds. He handed it back. "That doesn't mean anything. We still need to verify your immigration status." Judge Sterling's jaw tightened. "You just looked at federal judicial credentials and dismissed them. This is unlawful detention. I'm ordering you to step aside and let me leave." "You're not ordering us to do anything."
Mendoza's voice came from behind her. "We have authority under federal immigration law to conduct stops and verify status. Not without individualized, reasonable suspicion, you don't. And you certainly don't have authority over a sitting federal judge. This encounter is over." She moved toward her driver's door. Brennan stepped forward, blocking her path. His hand moved to his handcuffs. That's when Judge Sterling made the decision that would ultimately save her, but destroy them. She pulled out her cell phone and began recording. "I am Federal Judge Vanessa Sterling of the Northern District. I am being illegally detained by 2 ICE agents at the Shell station on Riverside Boulevard. I have presented my credentials. I have committed no violation. I am documenting this unconstitutional stop."
Turn off that phone. Brennan's voice rose. "You're interfering with a federal investigation." "I am the investigation, and this recording is evidence of your constitutional violations." Mendoza moved closer. His face appeared on camera. "Ma'am, if you don't comply right now, we will arrest you for obstruction." The absurdity of the threat hung in the air. 2 immigration agents threatening to arrest a federal judge for refusing an unlawful detention. But Brennan and Mendoza weren't thinking about consequences. They were thinking about control, about authority being challenged, about a black woman who wouldn't submit. Brennan grabbed Judge Sterling's wrist. The phone nearly dropped, but she held on. Mendoza moved in from the other side. Within seconds, they had forced her against her own vehicle. The phone was still recording, now capturing shaky footage of the gas station pavement and the agent's boots. "You are making a catastrophic mistake." Judge Sterling's voice remained steady even as metal handcuffs closed around her wrists. "I am a federal judge. You are committing multiple federal crimes right now. Save it for processing." Brennan guided her toward their SUV. Other gas station customers stood frozen, watching a woman in a tailored suit being arrested at a fuel pump. 3 people were recording now. One man shouted, asking if she needed help. Mendoza told him to back away or face obstruction charges himself. The drive to the ICE field office took 19 minutes. Judge Sterling sat in the back seat, hands cuffed behind her, saying nothing. She had said everything that mattered already. Now she would let the system respond. And respond it would, with a force that Brennan and Mendoza couldn't begin to imagine. At the field office, they walked her inside like she was a dangerous criminal. Other agents glanced over with mild curiosity. Just another person being processed. Mendoza logged her into the system. Name, physical description, location of apprehension. He typed quickly, barely looking at the screen. Then came the part where they collect personal belongings. Judge Sterling's purse was emptied onto a metal table. Wallet, keys, lipstick, tissues, phone, and then the items that should have stopped everything immediately. Her judicial credentials, the ones Brennan had dismissed at the gas station. Her federal courthouse access badge with embedded security chip. Her bar association membership showing she'd been a licensed attorney for 23 years before her appointment to the bench. A business card identifying her as Judge Vanessa Sterling, U.S. District Court. The processing agent, a woman named Officer Rebecca Patel, picked up the credentials. She studied them carefully. She looked at Judge Sterling, then at Brennan and Mendoza, who were standing nearby filling out paperwork. "Did you see these?" Brennan barely looked up. "Yeah, they're fake." She claimed to be a federal judge, obviously lying. Patel had processed thousands of people. She knew what fake credentials looked like. These weren't fake. The holographic seals, the embedded security features, the weight of the cards, everything was authentic. She opened her computer and pulled up the Federal Judiciary Directory. "What's your full name and district?" "Judge Vanessa Sterling, Northern District." Patel typed. The search results loaded. There was the photo, matching the woman sitting in front of her. The biography listing her education, her appointment by the president 8 years ago, her confirmation by the Senate, recent cases she'd presided over. Everything matched. Patel's face went pale. She stood up slowly and walked directly to her supervisor's office. She didn't knock, just opened the door. Her supervisor, District Director Nathan Cross, looked up annoyed at the interruption. "We have a significant problem."
5 minutes later, Cross was standing in the processing area, staring at Judge Sterling. He'd pulled up the same federal directory on his own computer. He'd called the courthouse and confirmed she was scheduled to be in court that afternoon. He'd looked at Brennan and Mendoza's arrest report, which listed 0 specific violations, 0 reasonable suspicion, just vague references to an immigration verification stop. Cross had been with ICE for 15 years. He'd navigated political controversies, policy changes, and public scrutiny. But he'd never dealt with anything like this. His agents had just arrested a sitting federal judge without a warrant, without cause, without any legal justification whatsoever. "Release her immediately." His voice was quiet but sharp. "Remove the handcuffs, return all her belongings, and someone get me the agency's legal counsel on the phone right now." Judge Sterling stood as the handcuffs came off. She rubbed her wrists where the metal had pressed into her skin. She collected her belongings methodically, checking that everything was present. Her phone, still containing the recording. Her credentials, now validated. Her dignity, somehow intact despite everything. Cross approached carefully. "Your Honor, I apologize for this incident. There's been a serious misunderstanding." "Director Cross, there was no misunderstanding. Your agents conducted an unlawful stop, ignored federal credentials, and arrested a sitting federal judge. Those are facts, not misunderstandings. We'll be conducting a full internal investigation. You'll be facing a federal civil rights lawsuit and likely criminal charges for violating my constitutional rights under color of law." She walked toward the exit. Brennan and Mendoza stood against the wall, finally understanding that something had gone terribly wrong. Judge Sterling paused and looked directly at them. "You'll be hearing from me again. In court." The door closed behind Judge Sterling with a soft click that somehow felt louder than any slam could have been. She stood outside the ICE facility in the harsh afternoon sunlight, free, but fundamentally changed by what had just happened. Her phone buzzed immediately. 17 missed calls, 42 text messages. Her clerk, her staff, the courthouse security, all wondering where she was. She had missed an entire afternoon of scheduled hearings, cases that mattered, people whose lives depended on her rulings, left waiting while she sat handcuffed in a processing room for the crime of existing in her own skin. She didn't call anyone back yet. Instead, she opened the voice recording app on her phone. The file was still there. 23 minutes and 14 seconds of audio capturing every word spoken during that traffic stop. Every illegal question. Every ignored credential. Every moment of her constitutional rights being violated by federal agents who should have known better. Judge Sterling walked to her car, still parked exactly where Brennan had forced her to leave it. A parking ticket fluttered under the windshield wiper. Even that felt like a final insult. She pulled it out and actually laughed, a sharp, bitter sound that surprised her. Arrested without cause and ticketed for the privilege. The drive back to the courthouse took 30 minutes through heavy traffic. She used the time to think, to plan, to shift from victim back to judge. Because that's what she was, regardless of what agents Brennan and Mendoza saw when they looked at her. A federal judge with the full power of the judiciary behind her. When she arrived, the courthouse was in controlled chaos. Her clerk practically ran to meet her at the entrance. "Judge Sterling, we've been trying to reach you for hours. Are you all right? What happened?" "Reschedule everything from this afternoon, clear my calendar for tomorrow morning, and get me the contact information for the Department of Justice Office of Professional Responsibility and the Inspector General for Homeland Security." Her chambers felt different when she entered. The same mahogany desk, the same leather chair, the same law books lining the walls. But she wasn't the same person who had left that morning. Something had shifted. The theoretical cases she presided over, the abstract questions of constitutional law and civil rights, they weren't abstract anymore. They were personal. They were real. They were burned into her wrists where the handcuffs had been. She spent the next 4 hours making calls. The first was to her husband, a college professor who listened in stunned silence as she explained what happened. The second was to her attorney, because even judges need lawyers when their rights are violated. The third was to the chief judge of her district, because this wasn't just a personal matter. This was an assault on the judiciary itself. By 7 that evening, the machinery of justice had begun its grinding work. The Department of Justice opened a preliminary inquiry. The Inspector General's office assigned investigators. The Chief Judge issued a statement expressing grave concern and demanding a full accounting. And Judge Sterling's attorney filed a notice of intent to sue, the first step toward a federal civil rights lawsuit that would cost the government far more than money. But that was just the official response. The unofficial response was spreading through the legal community like wildfire. Judges talked to other judges. Attorneys shared the story with colleagues. Law clerks posted about it on private forums. By the next morning, every legal professional in the district knew that 2 ICE agents had arrested a sitting federal judge, and the implications were staggering. Meanwhile, back at the ICE facility, Director Cross was having the worst night of his career. He sat in his office reviewing the arrest report for the 100th time, searching for anything that might justify what his agents had done. There was nothing. No warrant, no probable cause, no reasonable suspicion. Just 2 agents who saw a black woman and decided that was sufficient reason to demand papers and make an arrest when she objected. The agency's legal counsel had been brutally clear. This case was indefensible. The agents had violated clearly established constitutional rights. Qualified immunity wouldn't protect them. The agency would likely lose any lawsuit. The only question was how much it would cost. Cross called Brennan and Mendoza into his office at 6 the next morning. Both agents arrived looking exhausted. Word had spread through the facility about exactly who they had arrested, and neither had slept well. You're both suspended without pay, effective immediately. You'll surrender your badges and firearms. You're prohibited from discussing this case with anyone except your attorneys and our investigators. Do you understand? Brennan's jaw tightened. This is political correctness gone crazy. We were doing our jobs.
Your job doesn't include arresting federal judges without cause. Your job doesn't include ignoring valid credentials. Your job doesn't include violating constitutional rights. She showed us a fake ID. Anyone can print a card. Cross slid a printed page across the desk. It was Judge Sterling's official biography from the federal judiciary website, complete with her photo, her credentials, her 8 years on the bench. Anyone can print a card, but not anyone can have their photo and biography on the official federal court website. Not anyone can be listed in the National Judiciary Database. You didn't check because you didn't want to believe her. Mendoza spoke for the first time. What happens now? Now you get attorneys. Good ones. Because the Department of Justice is investigating you for civil rights violations under color of law. That's a federal felony. And Judge Sterling will be filing a civil lawsuit. You're both looking at criminal charges and personal financial liability. The color drained from Mendoza's face. We could go to prison? Cross nodded. People have gone to prison for less egregious violations than arresting a federal judge without cause. The investigation moved quickly because the evidence was overwhelming. The dashboard camera from the ICE vehicle showed the entire stop. Judge Sterling's phone recording captured every conversation. The processing paperwork documented the arrest. There were no gaps, no ambiguities, no questions about what happened. Within 2 weeks, the Department of Justice made its decision. Criminal charges would be filed against both agents: deprivation of rights under color of law, false arrest, and abuse of authority. Each charge carried potential prison time. The civil lawsuit followed shortly after. Judge Sterling's attorney filed a comprehensive complaint in federal court. It named Brennan and Mendoza individually, named ICE as an agency, and named the Department of Homeland Security. The damages sought were substantial, but the complaint made clear this wasn't primarily about money. It was about accountability. The case was randomly assigned to another federal judge in the same district. Judge Thomas Crawford had served on the bench for 12 years and knew Judge Sterling professionally. He read the complaint with increasing disbelief.
then reviewed the evidence attached as exhibits. The recordings, the video, the documented timeline. Everything confirmed exactly what the complaint alleged. This will not be a long trial, he thought. This will be a settlement negotiation. He was right. The government's attorneys reviewed the same evidence and reached the same conclusion. They had no defense. Their own agents' actions were documented beyond any possibility of dispute.
Going to trial would mean playing that dashboard camera footage for a jury, letting them hear two federal agents dismiss a judge's credentials as fake, watching them arrest her without legal justification. Settlement discussions began within a month. The government offered $500,000. Judge Sterling's attorney countered with $2.5 million. Not because Judge Sterling needed the money, but because the number had to be large enough to hurt, to force systemic change, to make sure this never happened to anyone else. The negotiations continued for weeks. Meanwhile, the criminal case moved forward on a parallel track. Brennan and Mendoza both retained private attorneys using their life savings. Both were advised to consider plea agreements because taking these charges to trial was effectively suicide. Brennan refused. He maintained he'd done nothing wrong, that he was being persecuted for enforcing immigration law. His attorney told him he was making a catastrophic mistake. Brennan fired his attorney and hired another one, who told him the same thing. Mendoza was more realistic. She understood that the evidence was damning, that her career was over, that her only hope of avoiding significant prison time was cooperation. Her attorney negotiated a plea deal. Mendoza would plead guilty to 1 count of deprivation of rights under color of law. She would testify against Brennan if his case went to trial. In exchange, prosecutors would recommend probation instead of prison. She took the deal. Standing in federal court, ironically just 2 floors below where Judge Sterling's chambers were located, Mendoza pleaded guilty. She admitted that she had participated in an unlawful stop and arrest. She acknowledged violating Judge Sterling's constitutional rights. She accepted responsibility for her actions. Judge Crawford, presiding over the plea hearing, asked if she understood what she was admitting. Mendoza said yes. He asked if anyone had forced or coerced her plea. She said no. He accepted the guilty plea and scheduled sentencing for 3 months later. Brennan watched all of this happen and still refused to accept reality. His new attorney begged him to reconsider. The evidence was overwhelming. His former partner had turned against him. He was going to lose at trial and face years in federal prison. Please, his attorney said, take a deal while there's still time. Brennan refused. He would take his chances with a jury. He believed 12 ordinary citizens would understand he was just doing his job, just following procedures, just trying to enforce the law. His attorney knew better, but couldn't force him to see reason. The civil settlement was finally reached 4 months after the arrest. The government agreed to pay Judge Sterling $1.8 million. More importantly, they agreed to policy changes. All federal agencies would implement mandatory training on implicit bias and proper identification verification. Dashboard cameras would be reviewed quarterly for constitutional violations. Agents who made unlawful stops would face immediate suspension pending investigation. The settlement terms were made public, and the dollar amount made headlines. But Judge Sterling cared more about the policy changes. She wanted to prevent this from happening again, to the next person, to someone who didn't have her resources or legal knowledge. The criminal trial against Brennan began 6 months after the arrest. The courtroom was packed. Local media filled the gallery. Civil rights organizations sent observers. Federal employees came to watch one of their own face justice. The prosecution's case was devastating from the opening statement. They walked the jury through every moment of that traffic stop. They explained how Judge Sterling had done nothing wrong, had presented valid credentials, had asked reasonable questions. They showed how Brennan ignored all evidence contradicting his assumptions, how he invented justifications after the fact, how he arrested a federal judge for the crime of questioning his authority. The dashboard camera footage played on large monitors.
Every juror watched as Brennan dismissed Judge Sterling's credentials without even examining them properly. They heard him tell her to stop talking, to stop asking questions, to comply or face arrest. They saw him handcuff a woman who had committed no violation whatsoever. The prosecution called Mendoza as a witness. She testified for 3 hours. She explained that she had tried to tell Brennan they should verify the credentials. She admitted she should have tried harder, should have insisted, should have refused to participate. She acknowledged her own guilt, but made clear that Brennan had been the driving force behind everything that happened. Cross-examination was brutal. Brennan's attorney tried to paint Mendoza as a liar trying to save herself. He suggested she was the one who wanted to make the arrest and was now blaming Brennan. But the dashboard footage contradicted everything he claimed. The video showed exactly who made each decision, who gave each command, who chose escalation over verification. Expert witnesses testified about proper law enforcement procedures. A former ICE supervisor explained that Brennan had violated every protocol designed to prevent exactly this kind of mistake. A constitutional law professor walked the jury through the Fourth Amendment, explaining how Brennan's actions constituted a clear violation of Judge Sterling's rights. Judge Sterling herself took the stand. She described the humiliation of being arrested in her own vehicle. She explained how she had remained calm despite knowing she was being unlawfully detained. She recounted the fear she felt, not physical fear, but fear that anything she did or said would be used to justify violence against her. The defense tried to suggest Judge Sterling had been uncooperative, that she had escalated the situation by asking questions. Her attorney objected immediately. Asking questions is not a crime. Asserting your rights is not obstruction. The judge sustained the objection and instructed the jury to disregard the implication. Brennan took the stand in his own defense. His attorney had advised against it, but Brennan insisted. He needed to explain himself, to make the jury understand. His testimony was a disaster. He claimed he had reasonable suspicion based on Judge Sterling's presence in a high-traffic area for undocumented individuals. The prosecution immediately challenged this. What high-traffic area? A residential street in a middle-class neighborhood? Brennan couldn't provide specifics. He said Judge Sterling seemed nervous. The dashboard footage showed her perfectly calm. He claimed her credentials looked suspicious. He couldn't articulate what specifically seemed suspicious about valid federal documents. The prosecution destroyed him on cross-examination. They played the video again, pausing at key moments. When exactly did you verify these credentials before dismissing them? Brennan admitted he hadn't run them through any system. Did you call the courthouse to confirm Judge Sterling's identity? No. Did you consult a supervisor before making the arrest? No. Did Judge Sterling commit any traffic violation that justified the initial stop? A long pause. No. So you stopped her based on what exactly? Another pause. Her appearance in that area at that time. Her appearance, yes. And what about her appearance made you suspicious? Brennan realized the trap too late. There was no answer he could give that wouldn't sound like exactly what it was. The jury deliberated for 4 hours. They returned guilty verdicts on both counts: deprivation of rights under color of law and making false statements in official reports. Brennan sat motionless as the verdicts were read. His attorney placed a hand on his shoulder, but Brennan didn't react. Sentencing was scheduled for 2 months later. Brennan remained free on bond until then, but his life as he knew it was over. The federal conviction meant he could never work in law enforcement again. His pension was forfeit. His reputation was destroyed. Mendoza's sentencing came first. She stood before Judge Crawford, the same judge who had accepted her guilty plea. Her attorney presented letters from family and colleagues describing her years of service, her previously clean record, her genuine remorse. Mendoza herself addressed the court. She apologized to Judge Sterling, who sat in the gallery. She acknowledged that following orders was not an excuse, that she had her own moral responsibility to refuse unlawful commands. She said she would spend the rest of her life trying to make amends. Judge Crawford sentenced her to 3 years of probation, 500 hours of community service,
and a $10,000 fine. He noted that her cooperation and genuine remorse weighed heavily in his decision, but emphasized that what she did was serious, that she had betrayed her oath and violated someone's fundamental rights. Mendoza accepted the sentence without appeal. Brennan's sentencing 2 weeks later was entirely different. He showed no remorse. His attorney presented a sentencing memorandum arguing that Brennan had acted in good faith, that mistakes happen in law enforcement, that prison time would be excessive. The prosecution's memorandum told a different story.
It detailed Brennan's history of complaints, the pattern of stops targeting people of color, the multiple warnings from supervisors that he had ignored. This was not one mistake. This was a pattern of constitutional violations that finally caught up with him. Judge Sterling submitted a victim impact statement. She described the lasting effects of being treated like a criminal in her own community. She explained how she still felt anxiety during any interaction with law enforcement, how the arrest had undermined her sense of safety and belonging. She noted that as a judge, she understood the legal system better than most victims, yet still felt powerless in that moment. What about people without her knowledge, resources, or position? How many others had Brennan violated who never got justice? Judge Crawford read the entire statement aloud in court. Then he addressed Brennan directly. You were given authority and power to serve your community. You abused that power. You targeted someone based on assumptions and bias, then arrested her when she dared to question you. Even now, after a jury convicted you, you show no understanding of what you did wrong. That concerns me deeply. The sentence was harsh. 30 months in federal prison, 3 years of supervised release following incarceration, a $50,000 fine, restitution to Judge Sterling for attorney fees and costs. Brennan's attorney immediately filed notice of appeal, but everyone in that courtroom knew it was futile. The evidence was overwhelming, the verdict sound, the sentence within guidelines. The appeal would fail. Brennan was taken into custody immediately. No more freedom while waiting, no more chances to flee or influence anyone. Federal marshals placed him in handcuffs and led him out of the courtroom. The same handcuffs he had placed on Judge Sterling now bound his own wrists. The symmetry was not lost on anyone present. Judge Sterling watched him leave. She felt no satisfaction, no sense of victory, just exhaustion and sadness that it had come to this, that someone entrusted with authority had abused it so thoroughly. Outside the courthouse, reporters surrounded her. She made a brief statement. Justice has been served, but justice delayed is justice diminished. This should never have happened. The system failed long before that traffic stop. Multiple complaints were ignored, warning signs dismissed, patterns overlooked. Real accountability means preventing these violations, not just punishing them after the damage is done. The reporters dispersed within minutes, but the real fallout was just beginning. Within 24 hours, a civil rights organization filed a class action lawsuit against the entire police department. They had compiled records going back 7 years, showing systematic patterns of racial profiling, unlawful stops, and retaliatory arrests. Judge Sterling's case wasn't unique. It was just the one that finally made headlines because of who she was. The lawsuit identified 43 other victims. A teacher arrested for jaywalking after questioning why an officer stopped him. A nurse detained for suspicious behavior while sitting in her own car outside her apartment. A college student handcuffed for matching the description of a suspect who is 6 inches shorter and 30 pounds heavier. A grandfather tackled during a wellness check his own daughter had requested. Every single victim was Black or Latino. Every single officer involved had complaint histories that were ignored. The patterns were undeniable once someone actually looked. But here's what made it worse. Internal Affairs had the data all along. They knew which officers generated the most complaints. They knew which precincts had the highest rates of use of force against minorities. They knew supervisors were signing off on questionable arrests without proper review. They simply chose not to act Because acting would mean admitting there was a problem, and admitting problems meant liability, bad press, budget fights, political headaches. So they buried it, filed reports in databases no one searched, marked complaints as unfounded without real investigation, transferred problem officers to different districts instead of firing them. The system protected itself while the community suffered. The discovery process in the class action revealed emails that should never have been written. Supervisors joking about arrest quotas in certain neighborhoods. Officers sharing memes mocking people they had detained. A lieutenant telling subordinates to find reasons to stop people in high-crime areas, which was code everyone understood. The department's own training materials included outdated techniques that civil rights experts said practically encouraged constitutional violations. None of this was accidental. It was institutional rot that had been festering for decades. Judge Sterling became the face of the lawsuit, though she never wanted that role. She gave depositions, appeared at hearings, testified before city council. Every appearance meant reliving that traffic stop, answering questions about how it felt, explaining the fear and humiliation over and over. She did it anyway, because the 43 other victims deserved someone with her platform fighting alongside them. Most of them didn't have legal backgrounds. Most couldn't afford the kind of attorneys this case required. Most would have been ignored if they had tried fighting alone. The city's defense strategy was predictable. They claimed these were isolated incidents by officers who didn't represent department values. They pointed to diversity training programs and community outreach initiatives as proof they took these issues seriously. They argued that policing is difficult, that split-second decisions sometimes go wrong, that hindsight is 20/20. Their attorneys painted the officers as dedicated public servants who made honest mistakes under pressure. The problem was the evidence. Thousands of pages of data showing the mistakes somehow always happened to the same communities. Video footage from body cameras and dash cams showing officers lying in their reports. Testimony from sergeants admitting they approved arrests without reviewing the facts because they trusted their officers' judgment. That trust was misplaced, and now the city was paying for it. 18 months after the lawsuit was filed, the city settled. $230 million, split among the 43 victims and their attorneys. Comprehensive reforms, including independent oversight, mandatory body cameras that couldn't be turned off, automatic review of any arrest where charges were dropped, and termination for officers who filed false reports. The police union fought every single reform, claiming they would make officers hesitant to act, that crime would skyrocket, that good cops would leave the force. Some did leave. Most stayed. Crime didn't increase. Complaints dropped by 60% within the first year. Judge Sterling received $4.7 million from the settlement. She donated $3 million to organizations supporting criminal justice reform. She used another $1 million to establish a legal defense fund for people who couldn't afford attorneys when challenging unlawful arrests. She kept the rest, not because she needed it, but because accepting it meant the city officially acknowledged what they had done to her. The money was accountability in its most tangible form. Brennan served 22 months before being released to a halfway house. Federal prisoners typically serve 85% of their sentence if they behave, and Brennan kept his head down. He worked in the prison library, took classes, stayed out of trouble. He never admitted guilt, never expressed genuine remorse, but he learned to say the right things during parole hearings. When he was finally released, he moved to a different state where no one knew his name or his history. He couldn't work in law enforcement anymore. His conviction made that impossible. He took a job doing private security at a warehouse, checking badges and watching cameras. The irony of a man who abused authority, now working minimum wage security, wasn't lost on anyone who knew his story. Mendoza had a different trajectory. Her cooperation and genuine remorse opened doors Brennan's defiance had closed. After completing probation, she became an advocate. She spoke at police academies about what she had done wrong and why. She testified before legislative committees considering reforms. She met with community groups who had every reason to hate her and answered their questions honestly, no matter how uncomfortable. Some people forgave her. Many didn't. She accepted both responses as consequences she had earned. Judge Sterling returned to the bench 6 months after the settlement. Some questioned whether she could be impartial in cases involving police testimony. She proved them wrong by ruling based on evidence, not emotion. She convicted defendants when the evidence warranted it and acquitted them when it didn't. She held officers accountable when they lied and credited them when they testified truthfully. Her experience made her better at her job, not worse. She could spot inconsistencies in police reports that other judges missed. She asked questions that revealed whether an officer truly had probable cause or was justifying a hunch. Defense attorneys requested her courtroom. Prosecutors learned they needed solid cases, not just a badge and a story. 3 years after the traffic stop, a reporter asked Judge Sterling if she thought anything good had come from what happened to her. She considered the question carefully before answering. Good isn't the word I would use. Necessary, maybe. My case forced changes that should have happened decades ago. But those changes came at a cost to me and 43 other people who never should have been violated in the first place. We shouldn't need federal judges to be unlawfully arrested before the system takes these problems seriously. We shouldn't need viral videos and lawsuits and public outrage before basic constitutional rights are protected. The fact that we do tells you everything about how broken things were. The police department still exists. Officers still make traffic stops. Arrests still happen. But the culture shifted in ways both measurable and subtle. Officers know their body cameras are recording and will be reviewed. Supervisors know signing off on bad arrests will cost them their jobs. The community knows they can file complaints that will actually be investigated. None of it is perfect. Systems created over decades don't transform overnight. But the trajectory changed, and that matters. Brennan's appeal failed, as predicted. His conviction stands. His prison sentence is public record. Anyone searching his name finds the full story of what he did and what it cost him. That permanent stain is part of his punishment, a reminder that authority without accountability eventually destroys those who abuse it. Some officers learned from his example. Others resented it, viewing him as a scapegoat for systemic problems. Both reactions missed the point. Brennan wasn't a scapegoat. He was someone who violated rights repeatedly until he finally faced consequences. The system that enabled him for so long deserved scrutiny too, and it got that scrutiny through the lawsuit and reforms that followed. Judge Sterling still drives past the intersection where Brennan pulled her over. She doesn't avoid it or take alternate routes. That corner doesn't own her. She reclaimed it by refusing to let what happened there define her or limit her movements. Sometimes she thinks about that moment, the lights in her mirror, the sinking feeling in her stomach. Then she keeps driving, exactly where she needs to go. That gas station on Riverside Boulevard still operates. People fill up their tanks every day, unaware of the history that unfolded on that concrete. But for Judge Sterling, for Brennan, for Mendoza, for the 43 other victims whose names never made headlines, that intersection represents something permanent. It's a reminder that badges don't grant immunity from consequences, that cameras capture truth that reports can't hide, that justice delayed is still justice when it finally arrives. The system failed repeatedly before it worked. Complaints ignored, patterns dismissed, violations rewarded with promotions instead of punishment. It took a federal judge being handcuffed at a fuel pump before anyone with power decided enough was enough. That reality should disturb everyone watching this, because it means countless others suffered without remedy, without witness, without the platform to force change. Real accountability isn't one verdict or one settlement. It's cultural transformation that makes these violations unthinkable instead of routine. Now, watching footage like this, it can really stick with you, right? Some of these clips stay in your head, especially late at night when you're trying to fall asleep. And speaking of sleep, A lot of you have told me you're waking up at 2 or 3 a.m. and just lying there. Can't shut your mind off. And the next day you're dragging through everything. I came across a simple 21-day sleep guide that's helped thousands of people fix exactly that. No pills, no apps, no gadgets. Just a step-by-step plan that actually works. It's only $15. I put the link in the description if you want to check it out. All right, I'll catch you in the next one.